This reading from Justia Law. Illinois Code Financial Regulation 205 ILCS 607 Consumer Installment Loan Act 2005 Illinois Code Chapter 205 Financial Regulation 205 ILCS 670 Consumer Installment Loan Act. ILCS 6701 from Chapter 17, Paragraph 5401, Section 1. License required to engage in business. No person, partnership, association, limited liability company, or corporation shall engage in the business of making loans of money in a principal amount not exceeding $25,000 and charge, contract for, or receive on any such loan a greater rate of interest, discount, or consideration therefore than the lender would be permitted by law to charge if he were not a licensee hereunder, except as authorized by this act after first obtaining a license from the Director of Financial Institutions, hereinafter called the Director. Source PA 89 through 400 EFF 28, effective 8/20/95, 90 through 437, effective 1/1/98, January 1st, 98. (205) ILCS, guess that's Illinois Code Statute or something, 672 from Chapter 17, Paragraph 5402, Section 2. Application, fees, positive net worth. Application for such license shall be in writing and in a form prescribed by the Director. Such applicant, such applicant at the time of making such application shall pay to the Director the sum of $300 as an application fee and the additional sum of $450 as an annual license fee for a period terminating on the last day of a current calendar year, provided that if the application is filed after June 30th in any year, such license fee shall be 1/2 of the annual license fee for such year. Before the license is granted, every applicant shall prove in form satisfactory to the Director that the applicant has and will maintain a positive net worth of a minimum of $30,000. Every applicant and licensee shall maintain a surety bond in the principal sum of $25,000 issued by the bonding company authorized to do business in this state and which shall be approved by the Director. Such bond shall run to the Director and shall be for the benefit of any consumer who incurs damages as a result of any violation of the act or rules by the licensee. If the director finds at any time that a bond is of efficient size, I'm gonna read that one over. If the director finds at any time that a bond is of insufficient size, is insecure, exalted, or otherwise doubtful, an additional bond in such amount as determined by the director shall be filed by the licensee within 30 days after written demand, therefore, by the director. Net worth means total assets minus total liabilities. Source, I'm not going to read the source. Y'all can see it. PA 92 through 398. I will read it. Effective January 1st, 02, 93 through 32, effective 7 1st, 03. (205) ILCS 673 from Chapter 17, paragraph 5403, Section 3. Appointment of attorney in fact for service of process. Every licensee shall appoint in writing the director of financial institution, hereinafter called director, and his successors in office, or any official who shall hereafter be charged with the administration of this act, an attorney in fact upon whom all lawful process amongst such licensee may be served with the same legal force and validity as if served on such licensee. A copy of such written appointment, duly certified, shall be filed in the office of the director, and a copy thereof certified by him shall be sufficient evidence. This appointment shall remain in effect while any liability remains outstanding in this state against the licensee. When summons is served upon the director as attorney in fact for such licensee, the director shall immediately notify the licensee by registered mail, enclosing the summons and specifying the hour and day of service. Source Law 1963, page 3526. And it's about 4 in the morning, 4 in the rising, excuse me. So peace. May the Most High bliss. Life is great and it's only getting greater. 205 ILCS 674 from Chapter 17, paragraph 5404, Section 4. Investigation to redact that. Section 4. Investigation to determine whether license shall be issued. Upon the filing of an application and the payment of the fee, the director shall investigate to determine 1. that the reputation of the applicant, including managers of a limited liability company, partner, owners, officers, and directors thereof, is such as to warrant belief that the business will be operated honestly and fairly within the purposes of this act, and 2, that the applicant meets the positive net worth requirement set forth in Section 2 of this act, unless the director makes findings herein above enumerated. He or she shall not issue a license and shall notify the applicant of the denial and return to the applicant the sum paid by the applicant as a license fee, but shall retain the 300 application fee. The director shall approve or deny every application for license herein within 60 days from the filing thereof with the fee. Source PA 90 through 437, effective 1/1/98, 90 through 575, effective 3/20/98. 205 Illinois ILCS 674.1 from chapter 17 paragraph 5404.1 section 4.1 repealed. Source PA 80 through 1004, repealed by PA 90 through 437, effective 1/1/98. 205 ILCS 675 from chapter 17 paragraph 5405, section 5, license. The license shall state the address, including city and state, at which the business is to be conducted, and shall state fully the name of the licensee. The license shall be conspicuously posted in the place of business of the licensee and shall not be transferable or assignable. Source PA 90 through 437, effective 1/1/98. 2005 ILCS 676 from chapter 17 paragraph 5406, section 6 repealed. Source Laws 1963, page 3526, repealed by PA 90 through 437, effective 1/1/98. 2005 ILCS 677 7 from chapter 17 paragraph 5407, section 7. More than one license to same licensee, changing place of business. A. Not more than one place of business shall be maintained under the same license, but the director may issue more than one license to the same licensee upon compliance with all the provisions of this act governing an original issues of the license. B. Whenever a licensee changes his place of business to a location other than that set forth in his license, he shall give written notice thereof to the director at least 10 days prior to the relocation. However, if the new location is in excess of 15 miles from the previous location, the licensee shall obtain written approval from the director prior to the relocation. Source PA 90 through 437, effective January 1st, 98. 205 ILCS 678 from chapter 17 paragraph 5408, section 8. Annual license fee expenses. Before the 15th day of each December, a licensee must pay to the director, and the department must receive the annual license fee required by section 2 for the next succeeding calendar year. The license shall expire on the 1st of January unless the license fee has been paid prior thereto. In addition to such license fee, the reasonable expense of an examination, investigation, or custody by the director under any provisions of this act shall be borne by the licensee. If a licensee fails to renew his or her license by the 31st of December, it shall automatically expire and the licensee is not entitled to a hearing. However, the director, in his or her discretion, may reinstate an expired license upon payment of the annual renewal fee and proof of good cause for failure to renew. Source PA 92 through 398, effective 1/1/02. 205 ILCS 670 8.1. Section 8.1. All monies received by the Department of Financial Institutions under this act shall be deposited in the Federal Institution Fund, created under Section 6Z through 26 of the State Finance Act. Source PA 88 through 13. 205 ILCS 679, chapter 17, paragraph 5409, section 9, fees, suspension and revocation of license. The director may, after 10 days, notice by registered mail to the licensee at the address set forth in the license, stating the contemplated action and in general the grounds therefor. Fine such licensee an amount not exceeding $10,000 per violation, or revoke or suspend any license issued thereunder if he or she finds that 1. The licensee has failed to comply with any provisions of this act in order, decision, finding, rule, regulation, or direction of the director lawfully made pursuant to the authority of this act. Or 2, any fact or condition existing which, if it has existed at the time of the original application for the license, clearly would have warranted the director in refusing to issue the license. B, the director may fine, suspend, or revoke only the particular license with respect to which grounds for the fine, revocation, or suspension occur or exist, but the director shall find that grounds for revocation or of general application to all offices or to more than one office of the licensee, the director shall find, suspend, or revoke every license to which such grounds apply. C, say blank. D, no revocation, suspension, or surrender of any license shall impair or affect the obligation of any pre-existing lawful contract between the licensee and any obligor. E. The director may issue a new license to the licensee which license has been revoked when facts or conditions which clearly would have warranted the director in refusing originally to issue the license no longer exist. F, let's say blank. G, in every case in which a license is suspended or revoked, or an application for a license or renewal of a license is denied, the director shall serve the licensee with notice of his or her action, including a statement of the reasons for his or her actions, either personally or by certified mail, return receipt requested. Service by certified mail shall be deemed completed when the notice is deposited in the U.S. mail. H, an order assessing a fine, an order revoking or suspending a license, or an order denying renewal of a license shall take effect upon service of the order unless the licensee requests in writing within 10 days after the date of service a hearing. In the event a hearing is requested, the order shall be stayed until a final administrative order is entered. I, if the licensee requests a hearing, the director shall schedule a hearing within 30 days after the request for a hearing unless otherwise agreed to by the parties. J, the hearing shall be held at the time and place designated by the director. The director and any administrative law judge designated by him or her shall have the power to administer oaths and affirmations, subpoena witnesses, and compel their attendance, take evidence, and require the production of books, papers, and correspondence and other records or information that he or she considers relevant or material to the inquiry. K, the costs for the administrative hearing shall be set by rule. L, the director shall have the authority to prescribe rules for the administration of this section. Source PA 90 through 437, effective 1/1/98. 205 ILCS 670 9.1, section 9.1, closing of business, surrender of license after 10 days prior to a licensee ceasing operations, closing business, or filing or bankruptcy. For bankruptcy, the licensee shall: A, notify the department of its action in writing. B, with the exception of filing for bankruptcy, surrender its license to the director for cancellation. The surrender of the license shall not affect the licensee's civil or criminal liability for acts committed prior to surrender, or entitled the licensee the licensee to a return of any part of the annual license fee. C, the licensee shall notify the department of the location where the books, accounts, contracts, and records will be maintained, and the procedure to ensure prompt return of contracts, titles, and releases to the customers. Man, it's early. I'm messing up. Excuse me, y'all. D, The accounts, books, records, and contracts shall be maintained and serviced by the licensee and another licensee under this act, or an entity exempt from licensure under this act. Licensure under this act. E. E. The department shall have the authority to conduct examinations of the books, records, and loan documents at any time after surrender of the license, filing of bankruptcy, or the cessation of operations. Source PA 90 through 437, effective 1198, 90 through 575, effective 3/20/98. And I want to see what this word means. Licensure. (205) ILCS 670-10 from Chapter 17, Paragraph 5410. Section 10. Investigation of conduct of business. For the purpose of discovering violations of this act or securing information lawfully required by it, the director may at any time investigate the loans and business and examine the books, accounts, records, and files used therein of every licensee and of every person, partnership, association, limited liability company, and corporation engaged in the business described in Section 1 of this Act, whether such person, partnership, association, limited liability company, or corporation shall act or claim to action as principal or agent, or within or without the authority of this Act. For such purpose, the director shall have free access to the offices and places of business, books, accounts, papers, records, files, safes, and vaults of such persons, partnerships, associations, limited liability companies, and corporations. The director may require the attendance of and examine under oath all persons whose testimony he or she may require relative to such loans or such business, and in such cases the director shall have power to administer oaths to all persons called as witnesses, and the director may conduct such examinations. The director shall make an examination of the affairs, business, office, and records of each licensee at least once each year. The director may, by rule and regulations, set the fee to be charged for each examination day, including travel expenses for out-of-state license locations. The fee shall reasonably reflect actual costs. The director shall also have authority to examine the books and records of any business made by a former licensee which is being liquidated, as the director deems necessary, and may charge the examination fees otherwise required for licensees. Source PA 90 through 437, effective 1198. And we're going to start right here. Books and records. But I'm going to come and I'm going to check out this because my eyes getting real heavy. real heavy. So I'm going to take me a little nap. It's 5:06 a.m. November 22, 2023 on the Gregorian calendar year. In the house of the Most High, the noble clan of the Xenon Royal Ministry. Also, let me see. So, what the word was? Licensure. Excuse me, pardon me. Licensure, right here. Legal definition of licensure. A state or condition of having a license granted by official or legal authority to perform medical acts and procedures not permitted by persons without such. And then it got right there, license, permission granted to qualified authority to permit. So the licensure is medical. And we're going to stop it right here.